Hi, everyone. Thank you for watching our overview for public officials on public meetings, records, and ethics. My name is Ashley DeGill, and we also have Ali Snyder and Connie Kong here with us today. We're all attorneys at Barry, Elser, and Hammond, and we'll be presenting on these topics for you. Next slide, please. So I'm going to be presenting on the first topics today. My name is Ashley DeGill, like I said. I specialize at BEH in primarily land use and public contracting, but I also do a little bit of everything public entity related. And our goals for today for this presentation is not necessarily for you to become an expert, but instead for you just to gain tools to recognize issues, to kind of issue spot as you practice as a public official, and then be able to ask us or another attorney for assistance. Our discussion topics are authority and public meetings, which I will be covering, and then public records, which Connie will be covering, and then government ethics, which Ali will be covering. Next slide, please. Okay, authority. So the first thing to remember for authority is just that you can only act as a body. Generally, your charters, codes, and ordinances do not grant power to individual public officials to act on behalf of their body or the local government. That means you can only act in your capacity as a body, not as an individual representing your public entity. Elected and appointed officials are also expected to abide by the decisions of their body, whether or not you voted on the prevailing side. So this means, even if you voted against a particular topic, but it ends up passing, you still are expected to abide by that new passed regulation, rule, etc. If an individual official is authorized to represent the local government before the public or another government agency, you must support and advocate for the official entity position on the issue. So that means, you can't go and represent your public entity and then advocate for your own personal opinions. You have to actually represent the opinions that the public entity hold. Your own personal opinions, of course, and comments are allowed to be expressed still. I mean, you are still a private citizen in addition to serving as a public official. So you are still allowed to express those personal opinions. But we do recommend that you make it clear when you're expressing those personal opinions that you are acting in an individual capacity and you aren't representing the local government's position. This can be as easy as when you make a social media post, for example, that is your own social media post that the public will be able to see, or some of the public will be able to see. You can just mention in that post that these are your own personal comments and they do not represent the local government's comments or opinions. Next slide, please. So public meetings. Generally, these are regulated by state statute 192-660 and following. And per the statute, elected and appointed officials must meet in public to make or deliberate towards a decision. Excuse me. And the purpose of these statutes is to encourage transparency in the government. Governing bodies of public bodies are subject to this requirement. And governing bodies is pretty broad. It is all decision-making bodies and advisory bodies. Decision-making bodies are typically entities or bodies that are making the decisions for the local government, such as city councils, boards of commissions, etc. Whereas advisory bodies advise the decision-making bodies. This could be planning commissions in certain contexts. It could also be boards, commissions, or committees that are formed by city councils, board of commissioners, etc. So it's quite broad, what governing body means in the context of public meetings. Next slide, please. So what is a public meeting? So state law addresses public meetings in two ways. First, all meetings of a public body must be in public. And second, a quorum of a public body may not meet in private. So we're going to break down both of these statutory requirements in a little bit more detail to really understand what is and is not a meeting, and therefore when you need to be ensuring that you are having your meeting comply with all of state regulations. Next slide, please. Sorry, can you, perfect, thank you. Can you switch to the next slide? Thank you. So going into a little bit more detail on what a meeting is. A meeting in the context of the public meetings laws means a convening of the governing body of a public body for which a quorum is required in order to make a decision or deliberate towards a decision on any matter. So we're going to break down this definition a little bit more and discuss what each of those red words means exactly, or red phrases. Next slide, please. So when is a meeting convened? If you recall, the first element of this definition of meeting is that the public body or the governing body of the public body convenes. So a public meeting is considered convened if the governing body first, if they gather in a physical location, that makes sense. If the entire public body ends up, or the entire governing body ends up in one place, such as at a public meeting, that is a meeting. If they use electronic, video, or telephonic technology to communicate contemporaneously, which means at the same time or in the same place. So in other words, if there is a video call, a phone call, etc., then that can still be a convening of a meeting. Also, serial electronic written communication can also be considered a convening meeting. This could be, for example, emailing or texting over a period of time, even if it isn't contemporaneous, that can still be considered convening a meeting. And then finally, using an intermediary to communicate. This means talking through a third party. And if enough of the public body officials in fact communicate through this third party, then a meeting could still be considered convened. Next slide, please. And just to break that down a little bit more, like I just mentioned, intermediary, that is the person who's used to facilitate communications among members of the governing body about a matter. And serial written communications, that's a series of successive or sequential communications among members of the governing body using written electronic means. And like I mentioned, that can include emails, text, social media, and other electronic applications that communicate the written word. So this is just to kind of show that it doesn't just have to be meetings where you're all together, or even where you're calling each other at the exact same time. It could also be through email, it could be through texts, or unfortunately even social media posts, if you have enough individuals all talking about a public matter that can create a public meeting. Next slide, please. Okay, so this is to go into a little bit more detail on that idea of meetings that aren't all at the same time or in the same place, and those are referred to as serial meetings. Serial meetings occur when a series of communications of any kind, directly or through intermediaries, are to discuss, deliberate, or take action between a quorum of a governing body. So again, this is where it isn't all at the same time or in the same place, but nevertheless, individuals in the governing body are discussing topics that may be better to be discussed at a public meeting. And this is true even though at no given time a quorum of the governing body communicates contemporaneously. So like I mentioned, just text messages or emails or social media posts can be sufficient. Next slide, please. Okay, so the next element of the definition of a meeting is a quorum. If you recall, a meeting requires convening, which we just discussed, of the governing body of the public body, for which a quorum is required. So what is a quorum? There is always some minimum number of members that must participate in order for a body to transact business. And this is considered the quorum of the body. Usually, a majority of the body equals a quorum. So, for example, if a planning commission is 7 members, then 4 members would be a majority of that public body, and typically a quorum would be 4, meaning you would have to have 4 planning commission members present in order for the planning commission to meet and conduct business. A gathering of less than a quorum of a governing body is not a meeting. So, in other words, if you had 3 or fewer of that 7-member planning commission who met together, or convened, then that would not be considered a public meeting. And I do encourage you to check your charter or your applicable ordinances just to confirm your specific quorum requirements, because even though this is typical, it's not always true for every public entity. Next slide, please. So now the final elements of the definition of meeting, which is, again, a convening of the governing body of the public body for which a quorum is required in order to make a decision or deliberate towards a decision. So these final two elements, decision and deliberation. A decision is any determination, action, vote, or final disposition on a motion, proposal, resolution, order, ordinance, or measure. So it's really just a final action on something that requires a vote. Whereas deliberation is discussion or communication that's part of the decision-making process. Next slide, please. So, in summary, from all of that, if more than a majority of your governing body meets outside an official public meeting and you are making or deliberating towards a decision, then you are violating the public meetings laws. So again, to just illustrate this in example, assume that 5 of 7 members of a Parks and Rec Commission are all at the same school play and start discussing the merits of whether to propose the creation of a city grant program that would support performing arts in schools. Have those members met in private for the purpose of deciding on or deliberating towards a decision? Well, so the first question would be, are they convening? Yes, they are all physically present at that school play. And so convening is met. Is it the governing body of a public body? Yes, this is a governing body. It's a Parks and Rec Commission for which a quorum is required. Yes, so we're just assuming here, for the sake of the hypothetical, that a quorum is a majority of the 7 members. Majority would be 4, and 5 are present. So a quorum is present in this example, and is required in order to make a decision or deliberate towards a decision. This is the key one. Were they making a decision? No, they didn't vote on anything. But were they deliberating? Maybe at the start, when they first attended the school play, they weren't talking about any city business, but then they started discussing the merits of the grant program. At that point, they changed this regular school play into a public meeting, or what should have been a public meeting. And at that point, they should have just not discussed the grant program at all. At that point, it should have been a public meeting. Next slide, please. Here's another example. A board member of a 5-member governing body forwards an email discussion they had with another member regarding a matter that is pending before the governing body to a 3rd member of the body. So this is involving 3 members of the governing body of a 5-member body. And again, assuming that a quorum is a majority, which is 3. At this point, 3 members have all communicated on this topic. And the purpose of the communication was to deliberate towards a decision, right? Because it's pending before the governing body. And therefore, the email exchanges in total would likely be a serial meeting and should have happened at a public meeting. Next slide. And then the final example, a citizen posts a comment on the city's Facebook page about an upcoming land use hearing, and the comment generates discussion, as it does. 3 members of the 7-member planning commission make comments and share opinions on the Facebook thread. That is acceptable, right? If we're assuming a majority is a quorum, a majority of 7 would be 4, and thus far, only 3 have participated. So we have less than a quorum participating so far. However, a 4th member reads the comment and also makes a comment. Now we have 4. And we have 4 who are commenting on the upcoming land use hearing on this Facebook thread. So now we do have a quorum. And because a quorum have communicated opinions on the social media site on a matter that will require a vote before their body, because the land use hearing does require a vote, the members may have created a serial meeting. Next slide, please. All right, executive sessions are the one main exception to meeting in public. Public bodies may meet in executive session only in specific situations, which are spelled out in state law, specifically in 192-660 sub 2. And some of these, there are a number of exception or executive session situations spelled out in that statute, but some of the more common ones include real property transactions, exempt public records, pending or threatened litigation, employees, and labor negotiations. Next slide, please. So executive sessions cannot be held for the purpose of taking any final action or making any final decision. You can only deliberate during an executive session. If you want to take a final action, you must exit the executive session and take that action at a public meeting. And the reason for this is to allow the public to know the results of the discussion, same as the public meeting requirement generally, right? Taking a formal vote in open session satisfies this requirement, even if the public vote just confirms consensus reached in the executive session. If the body meets in executive session, members should try to provide direction or consensus to staff, even if it's not followed by a formal vote. And all contact with other parties have to be left to designated staff or representatives handling the issue. In other words, we don't recommend exiting executive session and then attempting to further the purpose of that meeting yourself. Leave that to staff. Also, unless required by law, no member of a governing body should make public the discussions or information obtained in executive session. Generally, executive sessions are for the purpose of keeping certain materials confidential and private, and therefore, we do not recommend discussing those topics with individuals who are outside of your public entity. Next slide, please. So in order to enter executive session, you do have to follow specific procedures. The person that is presiding at the meeting has to announce the statutory authority for the executive session before going into closed session. So that means you have to actually reference the specific statute under which you are entering executive session. You also have to announce before going into the executive session if you plan to return to open session to take action. So in other words, if you're planning to vote after the executive session, then you have to say that before you go into executive session. Also, interestingly, media is allowed to attend executive sessions in most situations, although they can't report on what they hear during the executive session. But they can use the information that they hear to follow leads. So although executive sessions are confidential and potentially privileged, nevertheless, reporters can listen to what is heard there and potentially use it to follow leads. And that's an important thing to remember. Next slide, please. So despite the meetings requirements that we just went through, including executive sessions, there are certain circumstances that are just accepted from these meeting requirements. These include communications between or among members of a governing body that are either purely factual or educational in nature. This could include a training, for example. Also, anything that is not related to any matter that could reasonably be foreseen to come before the governing body. So if you know this will never be a matter that the governing body considers, then you can discuss it and it won't be subject to public meetings laws. Also, any topic that is non-substantive in nature. So this could include scheduling, leaves of absence, and other similar matters. All of those may be discussed with a quorum of the governing body of the public body or through an intermediary, and it isn't subject to public meetings laws. Next slide, please. So can a quorum of a governing body meet in social settings? Yes. I mean, think back to the school play hypothetical I gave earlier. That would have been totally fine if I think it was if the governing body entity, I'm not remembering the exact entity that it was in that situation, but if that governing body just had kept it social, if they hadn't talked about the matters that may be pending before their governing body. So as long as you keep the social setting social and you avoid discussing any sort of official business at the social gathering, then a quorum or more can be present at that social gathering. At any point when the conversation turns to official business, that's when you run the risk of inadvertently creating a meeting. And also, please remember that attendance at conferences, trainings, etc., are excluded from the definition of meeting as well. Next slide, please. Okay, So why is it so important to understand when something is a meeting versus when it is not? And it's because there are specific requirements and regulations around how meetings are noticed, where they're held, how they're conducted, etc. So for notice of the time and place of the meeting must be reasonably calculated to inform interested persons. For regular meetings, typically that means 48 hours in advance. For special, that means at least 24 hours in advance. And for emergency, it's just as much time as is reasonable given the circumstances. Personal notice must also be given to those who have requested it. And also the notice must address the principal subjects to be discussed. The summary of the principal subjects has to be specific enough to permit a person to decide if they feel it's necessary to attend, but it doesn't have to be incredibly detailed. Also, a public body is not precluded from considering additional items during the meeting. The notice just has to mention the principal subjects to be discussed. Next slide, please. For the location of the public meeting, it generally must be open to the public, and it cannot be held at a location that discriminates in any way that is listed here against any individuals. And it must also be within the jurisdictional boundaries of the public entity unless you're attending a training where no deliberations occur, or if you're in a meeting with another governing body, or if the meeting is conducted by phone or other electronic communication. Also, the location must be of a sufficient size relative to the expected interest in the meeting. This means that on occasion you have to change your location, perhaps. For a typical meeting, perhaps you have a certain number that usually attends, but maybe a particular topic is especially catching the interest of the public, and therefore you have to change your location or get more chairs or set up an alternative viewing location for individuals. It must also be accessible to persons with disabilities, and also you must provide remote access for public meetings when reasonably possible. Next slide, please. For voting, votes must be tallied and attributed to each member of the governing body, and you can use paper ballots, but they cannot be kept secret. All deliberations and final actions of the governing body have to be in public. Also, minutes must be kept for all public meetings. They don't have to be verbatim, and in some situations, an audio or video record of the meeting is enough instead of minutes. Minutes must also be made available within a reasonable time after the meeting, with the exception of executive sessions. Of course, for executive sessions, you still have to keep minutes, but you do not have to make them publicly available because they're private. Next slide, please. Okay, controlling public meetings. Generally, under state law, the public has a right to attend and observe, but not necessarily participate in public meetings. Sometimes state law or local ordinances or bylaws permit limited public participation or your local rules, for example, a public comment period. Often there will be a stated public comment period, such as 3 or 5 minutes for every individual who signs up in advance, or some other similar language. Usually time limits can be established for public comment so long as those standards are applied equally to all. This means that regardless of the subject matter, all individuals must be treated the same, right? And this freedom of speech requirement is quite broad, right? It allows almost any type of speech, regardless of your own personal opinions on that speech during a public comment period. And in the same line, you cannot remove a member of the public from a meeting unless you can clearly demonstrate that the individual is disrupting the meeting in a manner that precludes your governing body from conducting business. So in other words, removing a member of the public from a public meeting should be an absolute last resort, essentially where you are fearful for you or another member of the public's own safety, or where the member of the public is physically disrupting the meeting. Short of those situations, and even in those situations, we recommend instead just simply calling a brief recess and attempting to handle the situation outside of the public meeting. But short of that situation, but we do recommend attempting to gain control of the public meeting without actually removing the individual from the public meeting. Next slide, please. So violations, any person can file a complaint with the Oregon Government Ethics Commission, or OGEC, for public meeting violations. Liability is personal, which means that the city isn't liable. You can be held personally responsible for violations, and OGEC can investigate, find a violation, and impose penalties. And although OGEC is the regulatory arm of the state, OGEC is also a very helpful resource for your own personal questions about ethics and public meetings. Excuse me. So if you, and we have their contact information later on in this presentation, but if you ever have a question, we highly recommend that you reach out to them as a free resource about any potential questions you have about meetings or ethics. A civil penalty can be up to $1,000 per violation unless you are acting on the advice of the public body's legal counsel. Another point for, asking us in advance for advice on how to act. Public money cannot be used to pay this penalty. Again, this is a personal violation. OGEC can also issue letters of reprimand, explanation, or education. And in some more extreme circumstances, they could even invalidate certain decisions. Next slide, please. Grievances. So this is a relatively new process. Grievances must be submitted in writing 30 days after the date of the meeting where the alleged violation occurred. Grievances have to include everything that is on the slide here, and they may be submitted by any member of the public against any public official, as long as they're submitted within 30 days of the meeting. The public body also has to post on its website where and how to submit grievances. So this means that it's much simpler for members of the public to submit grievances and to process grievances against public officials. Next slide, please. So another new requirement is this annual training. Every member of a governing body of a public body with total expenditures for a fiscal year of 1 million or more, that means expenditures of the public body, not of you individually, shall attend or view an OGEC approved public meeting training at least once during the member's term of office. So just as a little plug here, we at BEH, we do have an OGEC approved public meetings training, which is on our YouTube page, and you can view that at any time for free, and that will qualify for this training requirement. Next slide, please. So some takeaways from this public meeting portion of the presentation. First, governing body members should refrain from using the reply all function on emails. That's a really easy way to accidentally create a public meeting. So if at all possible, just reply individually to other members of your governing body. Also, governing bodies should refrain from serial communications via email, phone, text, face-to-face, or even social media postings like Facebook. And members of the governing body should not use staff or other individuals as intermediaries if you remember to talk to one another through a third party. Next slide, please. All right, and with that, I will turn the presentation over to Connie.
All right, thank you, Ashley. Okay, so my name is Connie Kong, and I am one of the attorneys here at Beery, Elsner and Hammond, and just doing a variety of different kinds of law, but kind of focusing on public contracting and labor employment. So today I'm just going to give you a brief overview of public records laws, just so that you know what your responsibilities are as board members. And then I will end with some practical tips that you can take home with y'all. So let's just start with kind of the overarching purpose of these public records laws. These laws exist so that the government is transparent and accountable to the public, but also recognizing that not all records should be made public, recognizing individuals' privacy, public safety. And so there's a bit of a balance there. So let's start with the slides. So what does the law require? Two things. It requires both inspection and preservation. In other words, it requires retaining the public record so that the public can view it upon request. And this law applies to every public body. And by public body, I mean a governing body such as staff or city council, but it also includes members of boards, commissions, and task forces. So in other words, it applies to both employees and volunteers. And what exactly is a public record? It's a very expansive definition. Basically, it's any communication containing information related to the conduct of the public's business that the public body prepared, owned, used, or retained. An important part of that definition is it doesn't have to be created by the public body necessarily. And the physical form of the public record does not matter. For example, it could be paper or electronic, and the length of it also does not matter. It could be short, like a text message, or long, like a book. And it may not even have any words, such as a photograph. There's also some other examples on the slides. For example, notes taken during public body meetings or texts and social media posts that relate to official business. Now, there are some exemptions from this law, recognizing that some information does need to remain confidential. Again, as I said, to protect individual privacy, public safety, or maybe perhaps there's an ongoing investigation. So exemptions do exist, but they are very specific. And at the bottom slide, there's just some FYIs that when there has been, if there is a public record request, the public body can charge reasonable fees to provide that for that inspection. Okay, so next slide, please. Okay, so I'm going to focus on the preservation part of the public records law for this slide, because it's probably most relevant to you all as board members. Public body must follow a policy to retain public records, and this policy is set out with guidelines from the Secretary of State Archives Division, and that dictates how long a particular public record must be retained, and the length of time is specific to the kind of public record. It's also important to note that destruction of a public record is a criminal offense. So if you're unsure that something is a public record, it's better to err on the side of caution and consider it a public record. Some tips for y'all. Find out what the record retention policy is for your specific situation. Very likely that there is a city or county staff person to whom you can forward public records for preservation. And again, for example, emails, text messages, social media posts, etc. Okay, next slide, please. This is just a reminder of who the public record laws applies to. Again, not just officials or it includes employees and volunteers as well. And just an interesting FYI, when responding to a public record request, even something that has been deleted may still exist in a backup location, and therefore is still subject to inspection despite its location. Next slide, please. So just a summary of some takeaways for you. We've talked about the importance of the preservation of these public records and that they are subject to inspection with some limited exceptions. And some tips for you to take away. Know your city or county's public record retention policy and who to forward the public records to. Another suggestion, to keep notes or any documents in one spot. For example, if you're using a laptop, perhaps keeping everything in one folder, or if it's a physical notebook, just have one notebook dedicated to taking notes. And also, if you are using a personal device, such as a laptop or a phone, keep your personal information separate to avoid accidental disclosure if there is a public record request. And with that, I will hand it over to Allie, who will talk about ethics.
Thanks, Connie. Hi, everyone. My name is Allie Snyder. I'm also an attorney here at BEH. And uh, like many of us, I do a little bit of everything, but I particularly like thinking about constitutional law issues and public safety issues. But today we'll be talking about government ethics. So essentially, government ethics, the government ethics laws sort of serve as guardrails for uh, public officials to ensure that no public officials take advantage of their position. And so there are several sort of subsets of the government ethics laws that we'll talk about today: conflicts of interest, abuse of office, gifts, confidential information, nepotism, unlawful supervision, and the Oregon Government Ethics Commission, which we talked about a little bit already, as well as the violations that that commission can impose and the penalties that can result from those violations. So next slide, please. So conflicts of interest. These are an important thing to think about as you engage in your service. So a conflict of interest is basically anytime a decision that you're making as part of your public service would or could result in a private pecuniary benefit or detriment to you or your relatives or a business with which either you or your relatives are associated. And there's two different types of conflicts of interest: actual conflicts and potential conflicts. And essentially, just sort of like it sounds, an actual conflict arises when a decision that you make as a public official would definitely result in a benefit or detriment to you or your relatives or business with which you or your relatives are associated. Whereas a potential conflict arises when a decision that you are making as a public official just may result in that outcome. Next slide, please. And so just to zoom out a little, these laws implicate relatives, and relatives are defined by statute in a pretty broad way. So they include spouses, parents, kids, siblings, and the in-law versions of all of those, and step versions of all of those. Relatives also include anyone for whom you have a legal support obligation, typically kids, but not always, and anyone from whom you receive benefits from their employment. So basically, anyone whose salary supports you. And then some of these laws also implicate members of the household, and so that category includes, just like it sounds, anyone who lives with you, whether or not you are related under the statute. Next slide, please. And so we've also discussed how these laws implicate businesses with which you or your relatives are associated. And so just to kind of define businesses a little bit more, private businesses are included. If you are sort of involved at any level, you or your relative, director, officer, owner, employee, agent, or if you have more than $1,000 worth of interest in the business. So, small private businesses, if you're involved, that counts for the purposes of the law. Publicly held corporations, obviously they tend to be bigger, so involvement needs to reach a higher bar in order for them to be included in the ambit of these laws. And so if you or your relative is an officer or director of a publicly traded company, or if you or your relative has more than $100,000 worth of interest in that business, then that business is included in the ambit of the law. And then additionally, a business is a source of income if it produces 10% or more of your annual household income, and you're required to file a statement of economic interest. Next slide, please. So we've kind of defined what a conflict is. And now the question is, what do you do if you have a conflict? And it depends on whether the conflict is an actual conflict or a potential conflict. If it's an actual conflict, you need to declare that you have a conflict, and then you're done. You can't participate in a discussion, and you cannot vote on the matter. So declare and then stop. For potential conflicts, you still need to publicly announce that you have a conflict, but you can then vote and discuss. So just make it clear that you have a conflict, or that you may have a conflict, but you can continue on. Next slide, please. So there are some exceptions. You'll notice when we discussed businesses, that did not include nonprofits. So if you are involved in a nonprofit, but you receive no remuneration from that nonprofit, that doesn't trigger the conflict of interest laws. And then the class exception, this basically kicks in where you or your relative is a member of a class that might benefit from a decision. And this is a pretty nuanced exception. So if you think it might apply, contact us and seek legal counsel before hanging your hat on it. Next slide, please. So another exemption was recently created by the legislature via Senate Bill 983. And this bill establishes that elected officials can vote on budgets that contain compensation for themselves or for their relatives, and that does not constitute an ethics law. And that basically fixes a potential loophole identified by the OGEC, where they had previously issued an opinion that said that voting on such a budget could result in an ethics law violation. This is a legislative fix for that issue. And so now the situation is treated as a potential conflict. So if this occurs, you need to disclose and say, hey, I could benefit from this, or my relative could benefit from this, but you can then still continue to participate in the decision-making process, and you can vote on that budget. Next slide, please. So abuse of office. As a public official, you may not use or attempt to use your position to obtain financial gain or avoid financial detriment for yourself, your relatives, or members of your household that would not otherwise be available but for holding that position. There are lots of different acts that you can take that could constitute prohibited use of office. They range from making a vote in a certain way, rubber stamping a purchase order, using a car from the motor pool to conduct personal business, even using your computer that's been issued to you for public business only for personal business. So definitely a wide range of things that you need to tread carefully and ensure in order to ensure that you're not intentionally or unintentionally taking advantage of your office for personal gain. Next slide, please. So gifts. As a public official, you cannot solicit or receive gifts, and this also applies to members of your household and relatives as well. Cannot receive any gifts or look to receive any gifts that are total value of over $50 in a single year from a single source that has or could reasonably be expected to have a legislative or administrative interest in your decisions or votes. And a legislative or administrative interest means an economic interest distinct from that of the general public. So it's not enough just being a constituent doesn't constitute a legislative or administrative interest. It has to be someone who has a true economic interest in how you vote or how you decide. So it's key to keep track of the source of the gifts, both to ensure to understand who has a legislative or administrative interest, and to keep track of how those gifts are adding up over a single year. So to take a common example, going out for drinks, someone with a legislative or administrative interest is taking you out for drinks. It is okay for them to buy you 1 or 2 drinks, but you can't accept the total value of drinks that's more than $50. So, going out one night might be fine, but going out twice might not be. So you just need to really pay close attention to the cost of the gifts and ensure that it doesn't reach that over $50 threshold. Next slide, please. So what is a gift? It's anything of economic value, but statutorily, there are many different carve-outs. So a gift from your relatives or from members of your household, those don't count as gifts under the statute. Token type gifts, just a plaque for recognition, that doesn't count as a gift, so long as the resale value is less than $25. So it is somewhat important to pay attention to sort of the materials. If you get, typical plastic trophy or plastic plaque, that doesn't constitute a gift. But, if someone goes all out and gives you some, Waterford crystal or a real gold trophy, that will constitute a gift. And gifts received as part of your private doings, those don't constitute gifts. It's gifts that you receive as a public official. There are also other exemptions. For example, an unsolicited award that you're honored with for your professional achievements, that's not a gift. If you attend a conference in your official capacity, the meals and the swag that you might get, those do not constitute gifts. Next slide, please. So confidential information. As a member of a board or commission, you are privy to lots of confidential information. It's really important to keep this information in confidence. To the extent you read information, to the extent you hear information, just do not disclose it to anyone other than obviously your fellow board or commission members, the staff who you interface with as part of your work on a board or commission, or legal counsel who are advising you. Other than that, mum's the word and just do not discuss your official business. Sometimes the work that you engage in has public interest elements or controversial elements, and the media is going to be interested. It's not your responsibility to discuss those issues with the media, nor are you permitted to discuss those issues with the media. Public statements, information, and press releases regarding confidential issues, those will be handled by designated staff. So go through them. And you are not permitted to use confidential information that you have access to because of your position in order to personally gain. Next slide, please. So in terms of nepotism, it's a word we hear a lot, but what does it actually mean? Essentially, you may not, for your relatives or members of your household, you cannot appoint them, employ them, promote them, discharge them, fire them, or demote them unless you follow the conflict of interest protocols. You also cannot participate in interviews, discussions, or debates regarding your relatives or household members, period. And there's no safe harbor under the conflict of interest rules for the interview or discussion or debates. One exception to the above is unpaid volunteers. It is okay to appoint, employ, etc., your relatives or household members if they are unpaid and they're just operating in a volunteer capacity. Next slide, please. So unlawful supervision, pretty similar to nepotism. You can't supervise your relatives or household members. Pretty straightforward, and similar to the prior exception, you can supervise your relatives and household members so long as they are unpaid and they're simply operating in a volunteer capacity. Next slide, please. So the Oregon Government Ethics Commission, or OGEC, we've discussed this a little bit throughout this presentation, but just to drill down a little deeper, this is the commission that is tasked with impartially and effectively administering and enforcing Oregon's government ethics laws. So essentially, they are the commission that provides the teeth backing up the laws that we've been discussing. So they issue rules and opinions, they provide training, and they investigate and issue penalties for ethics violations. And so while they do have the power to impose penalties and identify violations, they're also an educational body and provide some really great trainings and really helpful advice, including one-to-one advice. So if you are ever concerned about what you may or may not do, you are welcome to contact the OGEC and get their take on it. And their contact information is displayed below. They're down in Salem and they're easy to access and friendly and easy to talk to. Next slide, please. So with that said, although they are, a helpful organization, they do have the power to impose penalties. And these penalties can be quite hefty. So in terms of a civil penalty, the maximum penalty that can be levied is $5,000, but civil forfeiture can be quite a bit higher. It can be up to twice the amount of any benefit that you might realize from an ethics violation. So if you engage in self-dealing and award yourself or a relative a contract that's worth $10,000, you could be on the hook for twice that amount, so a $20,000 forfeiture. So these fines and penalties can add up. Not all penalties are monetary. You can be issued letters of reprimand, explanation, or education. And one thing that's key to remember is that sanctions are personal to you as a public official. The government body that you serve will not pay your fines. You are personally on the hook. Next slide, please. So just the takeaways, just be really aware that of any actions that you might take that might affect your financial interests, your relatives' financial interests, or any businesses with which either you or your relatives are associated. And be aware, be on the lookout for any actions you might take that might affect members of your household as well. Pay attention to who has a legislative or administrative interest in the actions that you take, or who could be reasonably understood to have those interests, and pay attention to the value of the gifts that those people give you, and track them over each year. And if you are concerned that you may be violating or be about to violate an ethics law, contact OGEC before you do so, before you engage in that action. So that wraps up our presentation today. Thank you all for joining us. If you have any questions, we're always available to chat. You can reach out to any of us or to your primary contact at BEH. And we appreciate you watching and joining us.